Hello everyone. Good afternoon. Am I audible and visible to everyone, and is my screen visible too? Please comment in the chat box if I'm audible, visible, and if my screen is also visible to everyone. Yes, students, only if you confirm, then I'll continue. Okay, so Runa says yes. Right. So today we have a rapid revision on Indian Evidence Act 1872, and as you all know, we are here for the rapid revision series on MP Judiciary 2023. Good afternoon. Yes, good afternoon, everyone. So let us start with the Indian Evidence Act. Before I'll start the act, I just want to give you all the important sections. See, Indian Evidence Act is a very small act. According to me, it just has 167 sections. And apart from that, I feel Indian Evidence Act is very, very, very important. So no sections should be missed from the point of view of prelims, MCQ, right? But still, I'll be giving you some important sections which should not be missed at any cost. Okay. So, as you all know, that Indian Evidence Act is divided into three parts. How many parts is Indian Evidence Act divided into? It's divided into three parts, and it has 167 sections, and there are 11 chapters, right? So there is this three part which is divided into 11 chapters, and those 11 chapters are further divided into 167 sections. Previously we also used to have a schedule, but that schedule was repealed, so we don't need to include the schedule now. Okay, so I'm going to give all the important sections. Part 1. Now if you see part 1 of Indian Evidence Act, it only has chapter 1 and chapter 2. Okay, there are only two chapters under part 1. So from chapter 1, which is the preliminary chapter, you have to do section 3. Can you see the section which is mentioned here? Section 3 is important. If you are doing part 1, chapter 1 and chapter 2, from chapter 1, please do section 3. Section 3 is really important. In the previous years, we have seen lot of questions coming from section 3, and also, like, the definition part, which court definition is very important. When I will move further with the act, I'll tell you all. From chapter 2, which is of relevancy of fact, section 5 to 55, these are the important sections. Please note it down. If I'm going fast with the slideshow, please tell me, I'll wait. Okay, so you can note down these sections from section 5 to 50. See, every section is important, but still I have jotted down some sections from the previous year papers which have come continuously, which are repeated every year, and which should not be missed. So as you can see, section 5, 6, 8, 9, 10, 11, then 22, 23, 24, 25, 27, 30, 31, then 32 and 33, then 34, 40, 43, 44, 45 to 51 is important, and 54. Okay. Now I have divided it into in the way it is also divided in your Bear Act. If you see the head, the headlines, you will see admission under this chapter of relevancy of fact, then statements by person who cannot be called as witnesses, statements made under special circumstances, then judgment of courts of justice when relevant, opinion of third persons when relevant, and character when relevant. And I have given all these sections here. Yes, I'm saying again, go through all the sections, but these are the sections which should not be missed. Is my screen clear to everyone? Is my screen clearly visible to everyone? Saurabh, can you see my screen? Is it clearly visible to you? Okay. So if the screen is clearly visible, just jot down these sections which are mentioned here. That is 5, 6, 8, 9, 10, 11. Okay, is it chapter 1 preliminary only which you can see? And you all cannot see this chapter 2 of relevancy of fact? Is the second slide coming to you people, or only the first slide is visible? I'll just then, in that case, I'll go back. Part 1, chapter 2, which I showed you, preliminary, and this is the second chapter. I think now it is visible to everyone. Okay. Okay, I think now chapter 2 is visible in everyone's screen. Now, to some people, it might appear a little later, like, there might be a difference of 1 minute when it will reach out to you, but you will get it. Can you see chapter 2 now? Can you see all the sections 5, 6, 8, 9, 10, 11? Yes. So please mark down these sections. These are also important sections. It's of relevancy of fact, section 5 to 55, and these are the sections. 5, 6, 8, 9, 10, 11, 22, 23, 24, 25, 27, 30, 31, 32, 33, then 34, 40, 43, 44, 45 to 51, and 54. So part 1 will be done. Okay, part 1 only has two chapters, chapter 1 and chapter 2. Also remember one thing, all sections are important. I'm telling it again and again, but from the previous years which I have seen a trend, these sections are repeated a lot. So there are high chances that you will get these sections also in your like these sections should not be missed at least. Can I move on to the next slide now if everyone has copied this? I hope you all have the Bear Act with you. So I am moving on to the next slide. Okay. So part 2, which is on proof, the chapter is known as, the part is known as on proof, and there are uh, four chapters here: chapter 3, chapter 4, chapter 5, and chapter 6. In part 2, these are the four chapters which is uh, given in the Indian Evidence Act: chapter 3, chapter 4, chapter 5, and chapter 6. Now, chapter 3 is facts which need not be proved. Okay, facts which need not be proved. Here, all sections are important. So, read this chapter properly. All sections are important in chapter 3. From chapter 4, I have seen that section 59 and 60, that these sections are asked. If you all also see the previous year question paper, you will see these questions um, from this section coming. So chapter 4, go with section 59 and 60. Then chapter 5 is of documentary evidence. Now these are the important sections which I have marked: 62, 63, 65, 65B, 68, right? 62, 63, 65, 65B and 68. Then there is public document under chapter 5, which is uh, and the important sections here are section 74, 76 and 78. We have presumptions as to document again under chapter 5. From there you can just mark these sections: 81, 85A, 90 and 90A, right? I'm moving on to the next slide. Chapter 6. Okay, from chapter 6, which is of the exclusion of oral by documentary evidence: 91, 92, 93 and section 100. Okay, mark these sections: 91, 92, 93 and section 100. These sections I have marked from the previous year question papers. Seeing the previous year preliminary questions of MP Judiciary, I have come to these important sections which have been repeated. Okay, now come to part 3, which is the last part, and it has 5 chapters under its head: chapter 7, 8, 9, 10 and 11. So all the chapters which is left till chapter 11 is coming under part 3, which is production and effect of evidence. Now chapter 7 is a very important chapter. It is of burden of proof. So all sections I have marked all section, but still if you want to go to the more specific important section, I have seen a lot of questions coming from 101, 105, 106, 108, 112, 113B, 114A. Okay, so though from 101 to 114A, all sections are important in burden of proof, because I feel burden of proof is a very important chapter. But still, if you want more specific important which should not be missed, then please go through 101, 105, 106. So I have seen like questions repeating every year from 106 and 105, 108, 112, 113B, 114A, right? So these are important from chapter 7. Then chapter 8, Stoppel. See, it's important. There are only 3 sections, but still 115, read it carefully. Chapter 9 is of witnesses. Now, of witnesses chapter is again important, but coming to the more specific important section, it is 118, 119, 120 to 130. So 118, 119, then from 120 to 130. Acha, 126 is also important, between this 120 to 130, and 134 of witnesses. Coming to chapter 10, which is of the examination of witnesses, again an important chapter, but still more specific sections. If we see 134, 137, 139, 143. Now 134 is already in this chapter, okay, 9. So this is from chapter 9 only, right? So it is 137, 139, 143. Also write 141 in between. 141 is also important. Okay, 143. Then 146, 154, Write 151 and 152 also, right? 151, 152, 154, 157, 159, 164 and 165, right? 164 and 165. And the last chapter, chapter 11, is of improper admission and rejection of evidence. That is only section 167. So you just go through this section. That's it, right? This is chapter 11. So I hope everyone has marked all the important sections from the slides. Any doubt or anything is which you couldn't copy, please mention. If everything has been copied, then good. If not, please tell me which slide or which chapter you want to see again. Okay. So now we will move on to the the important parts which we have to discuss today. As I have already told you, if you see Indian Evidence Act is divided into three parts, right? There are three parts, and it's divided into 11 chapters. It's divided into 11 chapters, right? And 167 sections. So you can see here. Now, this is the updated Indian Evidence Act, because there have been certain changes, right? So I hope you all know that part one, the part which is part one, there are three parts. So part one is relevancy of fact. Part one is relevancy of fact. If you see part two, it is on proof. Okay. Part two is on proof. And part three is production and effect of evidence. Part three is production and effect of evidence, right? I have already explained just now when I was showing you the slides that part one has two chapters. Chapter one, which is preliminary chapter, which is from section 1 to 4, and chapter 2, which is of relevancy of fact, which is from section 5 to section 55. Then, if you see part 2, which is on proof, there are four chapters: chapter 3, chapter 4, chapter 5, chapter 6. Chapter 3 is from 56 facts which need not be proved, from 56 to 58. Chapter 4 is of oral evidence, 59 and 60. Chapter 5 is of documentary evidence, from 61 it is till 673A, right? Then we have public document from 74 to 78, presumption as to document from 79 to 82, from 79 to 90A, right? And then we have chapter 6, which is of the exclusion of oral by documentary evidence, from 91 till 100. Part 3 is production and effect of evidence. Okay, it is again divided into 5 chapters, from chapter 7 till chapter 11. Chapter 7 is important chapter of burden of proof. It is from 101 to 114A. Chapter 8 is estoppel, a very small chapter. 115, 116, 117 are the sections. Chapter 9 is of witnesses, right? It is from 118 till 134. Chapter 10 is of examination of witnesses, from 135 till 166. And chapter 11 is of improper admission and rejection of evidence, which only has one section, 167, and the schedule is repealed. This part is clear to everyone. The scheme of the act, how is the act divided, is, I hope, clear to everyone. Yes. Tell me in case of any problem, just let me know in the chat box so that I can repeat. If you want me to repeat anything, if you want me to answer anything, please write that in the chat box. Okay, students. So let me start with the first part and the preamble. If I tell you, now you can see here is written 15th March 1872, and this act may be called the Indian Evidence Act 1872. The commencement is first day of September 1872, right? So when did this act come into force? When did this act come into force? Questions might come from this part, preamble and the history of Indian Evidence Act. So what will you be choosing when it comes to the enforcement date? What is the enforcement date of Indian Evidence Act? Very good. 1st September. Which year? 1872. Very good, Saurabh. Now, evidence is derived from the Latin word evidere. Okay. It comes from the Latin word evidere. So, yes, evidence comes from the Latin word evidere. If you see this term, it's a Latin term. It's derived from a Latin term, evidere, and evidere means to show clearly. I'm sure you must have all, while reading evidence, you must have come across this word evidere. And evidere means to show clearly, or to make things, plainly certain, or to ascertain, or to prove. Because in Evidence Act, we are including all the legal means which is tending to either prove some fact or disprove any matter of fact, right? If I'm submitting some matter to judicial investigation, if I'm submitting some matter to judicial investigation, then I want all the legal means which will disprove or will prove my fact, which is an issue. So there should be no opinion, there should be no this whatever fact or argument we are putting, and whatever evidences we are giving, it has to be completely independent of any opinion or any argument. It should be based on evidence, right? So evidence is including all this legal means, which is exclusive. It will not include argument, or it will not include opinion, though we have section 45 to 51 where we will see opinion of experts, right? But with everything, you also have to see the evidentiary value of each. Now, can anyone tell me the evidence act, whether it is lex fori or lex loci? Anyone who can tell me what is Indian Evidence Act? Is it lex fori or is it lex loci? My question is Indian Evidence Act lex fori or lex loci? Arunima says lex fori. Lex fori is the correct answer. Very good. Arunima Sukrati also says lex fori. Shaktija, it is lex fori. Okay. Now, Indian Evidence Act is based on English law. ठीक है, अगर आप इंडियन एविडेंस एक्ट देखो तो it is based on English law, and it is known as lex fori. Lex fori, what does lex fori means? It means the law of the forum, or the place where the question has arisen, right? So it is a lex fori. That means law of the forum, or the place where the question has arisen. Second thing is that, again, one thing which is important regarding Evidence Act is that who is the father of Indian Evidence Act, right? Who drafted Indian Evidence? Later, it got converted into Indian Evidence Act 1872. But who is the father? Anyone who knows the father of Evidence Act? Very good, Arunima. Sir James Stephen. So, Sir James F. Stephens, you have to write. Sir James F. Stephen. F means again Fitz James. So, Sir James Fitz James Stephen. Correct, Shaktija. Right. So, the full name is written by Shaktija in the comment box. It is Sir James Fitz James Stephen. Okay, James and Fitz James is two separate two separate words in the name. And previously, originally, when it came, it contained 167 sections. Okay, so originally, when this act came, it contained 167 sections. It was divided into 11 chapters and one schedule. So this, now also we have 167 section, but now we don't have the schedule because that is repealed. Schedule was repealed in 1938. So now if you see Indian Evidence Act, it has only 167 sections, which is contained in 11 chapters, and it has three parts, right? And as I told you, it came into force on 1st September 1872. Right now, if I show you the a preliminary part of this act, which is relevancy of facts. Part 1 is relevancy of fact. Chapter 1 is preliminary. Part 1 contains two chapter. One is relevancy of fact and one is uh, chapter 2, which is of the relevancy of fact. Okay. So chapter 1, which is the preliminary part, we will see here the short title, extent and commencement of this act. See the short title, the extent and commencement of this act. Now this act is called the Indian Evidence Act 1872. It extends to whole of India. So previously it was not extending to whole of India, but after the Jammu and Kashmir Reorganization Act 2019, Indian Evidence Act is applicable now to whole of India, including the Union Territory of Jammu and Kashmir and Ladakh also, right? So this act, there it came into force on 31st October 2019, but now it is applicable to whole of India. Another part which I need to tell you is that law of evidence. What do you think? Is it a substantive law or is it a procedural law? Who can tell me? Is law of evidence substantive law or procedural law? Write it in the comment box. Is law of evidence substantive or procedural? Procedural. Okay. Yes. So yes, whenever this question comes up in MCQ, also we have to write procedural only. Very good. Eish. Yes. Eish has written as estoppel is substantive. Very good. Now, law of evidence is a procedural law. It only applies to court proceedings, right? But section 115 is substantive in nature, which is the doctrine of estoppel. So that is why it is becoming substantive. Otherwise, the whole part is procedural. But still sometimes we also say that it is adjective law. Now the meaning of adjective law is not clear, but adjective law are those laws which have both substantive and procedural aspects. Okay, what the definition of India states excluding J and K, it's a procedural law. Okay. Shaktija, I'm coming to this part, okay, to the extent which you are saying, excluding J and K, right? So, substantive law are those which refer to, rights and the rules and regulation. Procedural law is which is the law which contains the rules which help in enforcing this substantive law. And adjective laws which are containing both substantive and procedural aspect. Now, if you see Indian Evidence Act, it is mainly procedural, right? Since it has a substantive section of estoppel, therefore we can also say that it is an adjective law because it has both substantive and procedural aspects. But if question comes and adjective law is not mentioned, then you are only going to mention procedural law and not substantive law, because mainly the major part of Indian Evidence Act is procedural in nature only, right? So either you are going to mark procedural law or adjective law, right? So Indian Evidence Act is procedural or adjective, anything you can mention. Now one question is coming from Shaktija, which is definition of India states excluding J and K, right? So Shaktija, C, India means the territory of India excluding the state of J and K, right? Right. But see here, it is whatever is given here, which India states, right? Here the section is given this. But if you see the Jammu and Kashmir Reorganization Act now, right? So previously it was not applicable to whole of India. So before the commencement of Jammu and Kashmir Reorganization Act, it was not applicable. But now it is applicable to whole of India, including the union territories of Ladakh and Jammu and Kashmir. Because if we see Jammu and Kashmir Reorganization Act 2019, you will see the fifth schedule there. The word except the state of Jammu and Kashmir is omitted now. Okay, it has come into force from 31st October 2019. So you will the applicability of this act is to whole of India, including state of Jammu and Kashmir. Okay, this should be your answer. I'll come to that definition part also, but right now till the extent, just understand that it is extending to whole of India. Okay, it is extending to whole of India. Just keep this in mind. Second thing is it is applying to all judicial proceedings also. It is applying to all judicial proceedings also. If you see, this act applies to all judicial proceedings, right? Now, what are judicial proceedings? What do you mean by judicial proceeding? What do you mean by judicial proceeding? This section is specifying the territories. Okay, that is okay. It is Lex 4, it is okay. Now, you all tell me, what do you mean by judicial proceedings? Yes, I'll come to the difference between martial and court martial also. First, you all tell me this first part which we are dealing with. It applies to all judicial proceedings in or before any court, including court martial, right? So, who can tell me what do you mean by judicial proceeding? First, you have to make this clear. What do you mean by judicial proceeding? Anyone who knows about judicial proceeding? See, judicial proceeding, yes, presiding officer capable of collection of evidence. Okay, okay. So you are capable of collecting evidence, right? On oath. Yes, Arunima. This is the main point, right? On oath. So it is any proceeding in the course of which evidence can be legally taken on oath. So if you can take the evidence on oath legally, that is a judicial proceeding. Where is this meaning of judicial proceeding given? It is given in CRPC. If you see CRPC section 2, the meaning of judicial proceeding is given there. So the court, whichever court is, uh, is given this authority to take the evidence on oath, right? Those kind of proceedings will be regarded as judicial proceeding, right? And what are non-judicial proceedings? If I'm just conducting an inquiry about matters of fact, and there is I'm not taking it an oath, it is just a normal inquiry. So these are not judicial proceeding. Remember that. Like an inquiry by a collector. An inquiry by a collector is not a judicial proceeding. An order passed by first class magistrate under section 452 or 454 of CRPC is not judicial proceeding, right? A contempt proceeding is not judicial proceeding. So remember this. Now, judicial proceeding including courts martial. Now, there is a question which came in, right? Someone had asked this question. What is the difference between court martial and the court martial as specified in Army, Navy, and uh, In Army, Navy, Air Force Act. Yes. Now see, it is including court martial other than court martial convened under Army Act, Naval Discipline Act, Indian Navy Discipline Act, or the Air Force Act, right? So it includes court martial. Court martial is included, but these three are not included. What is not included in court martial? If you see, court martials is included, but it's not talking about court martial as convened under Army Act, Naval Discipline Act, Indian Navy Discipline Act, and Air Force Act. Right? So this is applying to native court martial and to proceedings before Indian Marine Act, right? But it does not apply to these which are under Army Act, Naval Discipline Act, Indian Navy Act. So there is no such difference. But according to Indian Evidence Act, it will not apply to the court martials which is under Army, Naval Discipline, and Indian Navy Discipline Act. That's it. What is a court martial? First, you will tell me. What is a court martial, student? Anyone knows what is court martial? What is court martial? पहले तो आप लोग ये बताओ कि कोर्ट मार्शल क्या होता है. What is court martial? Army disciplinary proceedings, Saurabh has said. Okay. Yes, so it's a trial only which is in military courts. Okay, so armies and armed services, they have a different trial proceeding. They have a separate trial proceeding in their own military court, right? So a court martial is a trial in a military court, right? Of so if you are breaking a military law or anything, right? If you are facing, so you will be tried by court martial. So there is no such difference, but it is only saying what that Indian Navy Act, Armed Force Act, this Air Force Act, Army Act, Naval Discipline Act, and Indian Discipline Navy Act is not included within this court martial. Other court martials are included. Other court martials apart from these are my native court martial and Indian Marine Act. So that so Indian Evidence Act will apply to the native court martial and to Indian Marine Act, but it is not going to apply to It is not going to apply to Army Act, court martials convened under Army Act, under Naval Discipline Act, under Indian Navy Discipline Act, and Air Force Act. So this is excluded. I'm not talking about the difference. There is no difference. Court martials means trial in a military court, but these are excluded from the Indian Evidence Act. Indian Evidence Act doesn't apply to these areas of court martial, that is Army Act, Naval Discipline Act, Air Force Act, and Indian Navy Discipline Act 1934. Clear? Clear to everyone? Right. So Saurabh had this question. Saurabh, clear? There is no such difference, but Indian Evidence Act is not applying to these four areas of uh, court martial. Right. Second thing, let me come to is that it does not apply to affidavits also. So Indian Evidence Act is applying to what is it's applying to judicial proceedings, right, including court martials. It applies to judicial proceeding including court martial, but these four areas of court martial are excluded, which is Indian Navy Act, Indian this what to say Army Act, Naval Discipline Act, Indian Navy Discipline Act, and Air Force Act. That is excluded. Then we are coming to this, but not to affidavits presented to any court or officer, nor to proceedings before an arbitrator. So Indian Evidence Act does not apply to affidavits also, right? It does not apply to affidavits. The reason for that is that the deponent who signs the affidavit, his assertion of facts on the basis of his personal knowledge is not an evidence, right? So if I today give a affidavit in the court that yes, I have not murdered A, so if I'm facing the accusation of if I'm charged with the murder of A, and I just submit in the court an affidavit saying that I dash 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 with this name, residing at this place, and whatever the format is, if I'm the deponent, and I'm just saying in the affidavit that I did not commit the murder of A, then is it will it be acceptable in the court of law? What do you think? If you place an affidavit, is it an evidence? We give affidavits for so many cases, right? But that is not an evidence. Why? Affidavit, why is affidavit not evidence? Why is affidavit not evidence? Because affidavit is on deponent's personal knowledge, right? And personal knowledge is not constituting, or your personal thing which you are saying. The personal knowledge is not constituting evidence. I am asserting fact, I am asserting a fact, or I am denying a fact on the basis of my personal knowledge. So my personal knowledge is not constituting evidence unless I could come with the proof of something, right? So I need to assert a fact or deny a fact with certain other things, and that is not my own personal knowledge, right? Yes, Shaktija, very good. Affidavit lacks evidentiary value, and Indian Evidence Act does not apply to proceedings before an arbitrator also, right? Why do you think it does not apply to proceeding before an arbitrator? So it is applying to judicial proceeding. It is applying to court martials also, except court martials which I have told. It does not apply to affidavit, and it does not apply to arbitration proceedings also. Why? Because arbitration proceedings are, again, proceedings of very special nature. They are not strictly governed by Indian Evidence Act, except the fundamental principles of fairness and the well established principles of evidence. It's not governed by Indian Evidence Act, right? So since arbitration proceeding is also of a special nature and Indian Evidence Act is also of a special nature, two special laws don't apply inter se, right? Since arbitration is done to save the court's time, it will lead to frustration of the legislative intent if we start applying the procedural laws of Indian Evidence Act. So arbitrator is free to evolve its own method of how he is going to admit the evidence, right? Therefore it does not apply to arbitration proceeding. I hope it's clear. Now tell me one thing, can we use affidavits as evidence anywhere else? Affidavits are not, Indian Evidence Act does not apply to, affidavits. Okay, affidavits presented to any court or officer, but can we use it as evidence? Any exception here? Any exception here? If you see the affidavit in interlocutory application, if the court is passing an order 39 of CPC for sufficient reason, in interlocutory application it can be used as evidence. So this can be one exception, right? That is order 39 of CPC. So I hope this part is clear, right? Now let me come to these commencement, which we have already discussed on the first day of September. Now let us come to interpretation clause, right? What is a court? Now court का definition हमेशा आता है in MP. So court includes all judges and magistrate and all persons except for sure arbitrators who are legally authorized to take evidence. Court definition comes in your exam also, in MCQ. So don't miss court ka definition, right? Then see the next part, which is fact. Now, this is a very important definition. We cannot miss this definition also. Fact means and include anything, state of things, or relation of things capable of being perceived by the senses, and any mental condition of which any person is conscious. So, my fact is including physical fact and psychological fact, right? And it means and includes. So, it does not only mean, but it also includes anything, any state of thing or relation of thing capable of being perceived by senses, any mental condition of which any person is conscious, right? Now, this is again one important definition that is relevant, right? So fact तो हम समझ गए, it's physical fact also and it's psychological fact also as defined under section 3. Please go through the illustrations also, which is given here. A man having a certain reputation is a fact. A man heard or saw something is a fact. Okay, go through the definitions also. Now coming to another definition, that is relevant. What do you mean by relevant? If two things are connected with each other, like today, if we are doing evidence ka rapid revision series, and if you start asking me from uh, Transfer of Property Act, right, and that two parts which are not relevant, then it is not relevant, right? Indian Evidence Act अगर है तो अगर आप मेरे से relevant provisions पूछते हो relating to what we are discussing today, that is okay. But if you start asking me something else, then it's not relevant to the topic. So therefore, relevant is something which is connected with the other, right? Which is connected with the other. Then come to the next definition, important definition, which is fact in issue. What is fact in issue? Again, it means and include. Okay. Again, it means and include what? It means and include. See, you have to read this separating and just bifurcating each part. Any fact from which, either by itself or in connection with other facts, the existence, non existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. So, it is any fact from which, either by itself or in connection with other fact, what are you getting? The existence and non-existence, the nature and extent of any right, liability or disability which is asserted or denied in any suit or proceeding which is necessarily following, right? So that is fact in issue. And if it is relating to CPC, any court records an issue of fact, whatever is asserted or denied in the answer of such issue is a fact in issue. So whatever one person is asserting and the other person is denying is a fact in issue, right? See the illustration also. Come to the definition of document. Now, document means any matter expressed or described upon any substance by means of letter, figure, mark, right? This is document. Evidence का definition important है. According to this definition, evidence is coming under two parts. One is oral evidence and one is documentary evidence. ठीक है? I have already told you evidence has derived from the Latin word evidere, which means to prove, to ascertain facts clearly and plainly. Now, here, according to Indian Evidence Act, it is oral evidence and documentary evidence. Okay. Now, documentary evidence includes electronic records also. Remember this. It also includes electronic records. Proved, disproved, and not proved. Again, important. Now, what fact is said to be proved? What facts are said to be proved? If, after considering the matter, the court is believing it to exist, अगर कोर्ट बिलीव कर रहा है कि ये मैटर एग्जिस्ट करना चाहिए, या कंसिडर करता है that the existence is very much probable, even if a prudent man ought, under the circumstances, he will also act upon the supposition that it is existing, then a fact is said to be proved. If, after considering all the matter before it, the court is either believing it to exist or considering that its existence is so probable that a prudent man will always also think it to exist. Disprove means after considering the matter, अगर कोर्ट बिलीव करता है कि ये एग्जिस्ट नहीं कर सकता है, या प्रोबेबिलिटी इसकी ये है कि प्रूडेंट मैन भी will think under these given circumstances that it does not exist, it is not disproved. Not proved hota hai when it is neither proved nor disproved. So something which is lying in between. Okay, that is said to be not proved, not proved. Okay, something which you cannot prove or which you cannot disprove is not proved. Now coming to the next definition, which is India, right? India means the territory of India excluding the state of J and K. Now this question came from Saurabh, no, Shaktija. The definition of India states excluding J and K, right? But here the applicability is the whole of India, which is including J and K. Now, who can tell me this definition? It is excluding state of J and K. Yes. Who can give an answer to this? Substituted by Act 3 of 1951, Section 3 and the schedule for the definition of state and states which were inserted by the AO 1950. Right? Yes. Anyone who wants to tell me about this definition? India, they are saying, means the territory of India excluding the state of J and K. What do you mean by this? Yes, please tell me. Who can tell me, students? Come with answers, start writing in the chat box. Yes. No answer? Anyone who can tell me about this section? Earlier J and K was excluded, now included. Yash has said. Right, Yash, correct. But then why is it written here India means territory of India excluding state of J and K when the thing is already updated here, right? When it is already an updated act, um, right? It's already updated and it was last updated on 13th March 2020. Then why this India is still saying excluding J and K? So yes, students, previously it was not included, but now it is included, right? After Jammu and Kashmir, what Yash has said, after Jammu and Kashmir Reorganization Act 2019, India ke under it is also J and K which is included. Okay, so take it in that way only, that it is included. J and K is also included here. Okay. Then come to may presume, shall presume, and conclusive proof. Again, very important part, which is coming under the presumptions. Okay, if we see the presumption chapter, may presume, shall presume, and um, conclusive proof. Very important, right? So presumption generally is presumption of fact and presumption of law and mixed presumption of fact and law. And one thing which you have to understand, there are two terms. One is irrefutable presumption and one is reputable presumption. So one presumption is rebutable, one presumption is irrefutable. Remember that also, right? So one is rebutable presumption, one is irrefutable presumption. And then we have mixed presumptions of law, which is presumption of fact and presumption of law together, right? So what is may presume, what is shall presume, and what is conclusive proof? Now, may presume is a part where the court and the party both, if you see the definition, if you see the definition, the court and even the party, both of them have the option to disprove. May presume means you can disprove it. The court and the party will both have the option to disprove the fact in may presume. In shall presume, the court and the party, in this only the party has the option to disprove. The court will not disprove, but the party can disprove. The court will presume, the court shall presume that a fact. The court shall presume a fact, right? And it shall regard it as proved. See, may presume it can regard it as proved. It may either regard such fact as proved, and here it shall regard such fact as proved unless and until it is disproved, right? But here or may call for proof of it. So in may presume, both court and party is having the option to disprove. But in shall presume, only the party is having the option to disprove, right? And conclusive proof is something where no one has the option to disprove. Remember this. No one has the option to disprove. Now, remember one thing which is very important is that may presume deals with rebutable presumption. May presume deals with rebutable presumption. Remember that. May presume is my rebutable presumption. And conclusive proof. If you see conclusive proof, then one of the most important provision which is relating with this is section 41, 82, 112 and 113. These are irrefutable forms of presumption or conclusive proof. 41, mark it, 41, section 41 is irrefutable or conclusive proof. 82 also is irrefutable presumption. 112 is also irrefutable presumption or conclusive proof, and 113 is also irrefutable presumption or conclusive proof. Remember it. Section 41, 82, 112 and 113 of Indian Evidence Act. Right? So this is it to my part 1. Now, since part 1 was important, we took a little time, not an issue. Hello, Geeta. Hello, Geeta. Yes. Okay. So can we move on to chapter 2, which is of relevancy of fact. Now here it's from section 5 till section 55, and you can see a lot of divisions also in between, right? Now section 5, if you see, of relevancy of fact, evidence may be given of facts in issue and relevant fact. What evidence can you give? पहले तो ये बता दो आप क्या क्या चीजों के लिए एविडेंस दे सकते हो, किन चीजों के लिए हम एविडेंस दे सकते हैं. Evidence may be given in any suit or proceeding of existence or non-existence of every fact in issue, right? And the explanation says this section shall not enable any person to give evidence of a fact which he is disentitled to prove by any provision of law for the time being in force relating to CPC. This is section 5. ठीक है, दैट इज व्हाट एविडेंस यू कैन गिव आइदर ऑफ फैक्ट इन इशू एंड रेलिवेंट फैक्ट. आप किन चीजों के लिए एविडेंस दे सकते हो? फैक्ट इन इशू के लिए या फिर आप रेलिवेंट फैक्ट्स के लिए भी दे सकते हो. नाउ कमिंग टू सेक्शन 6, which is very important, relevancy of facts forming part of same transaction. See section 6. Now section 6 को आपको बहुत अच्छे से पढ़ना है because it relates to the doctrine of which doctrine? Can anyone tell me? Section 6 relates to which doctrine? Write in the comment box, please. Section 6 relates to res gestae. Section 6 relates to res gestae. Now, res gestae is a very, very important provision when you see Evidence Act or Section 6 जो है, that is res gestae, facts forming part of same transaction. Now, those facts, though not in issue, are so connected with a fact in issue as to form part of same transaction are relevant, whether they occurred at the same time and place or at different times and places. This is what the section says, right? Now, what do you mean by the term res geste? Who can tell me the meaning of res geste? Very good, Saurabh and Sukriti. Can you all tell me what do you mean by res geste? Facts forming part of same transaction. The relevancy of facts forming part of same transaction. When we come to this term of res geste, what do you mean by res geste? इसका मीनिंग क्या होता है? Res and geste. What is the meaning of res geste? Section 6 res geste. What is the meaning? Anyone who can tell me the meaning of res geste? Res geste, initially you will see that the Romans used res geste, which means acts are done or actus. So res geste are acts which speak for themselves. Okay, they are forming part of transaction automatically or naturally somewhere. So acts done or actus. Res geste means acts are done or actus. Remember it, right? So facts which are so connected with the fact in issue forming part of same transaction are relevant fact, right? And what are the requirements to prove that facts are a part of the same transaction? They are in so much close proximity. They are in so much close proximity to time, so much so that there remains no possibility of fabrication. है ना? That you don't have time for fabrication of evidence. There is a common purpose, there must be a continuity in action, and they must have occurred at the same place or at different places also, but they are in close proximity to each other. So it means, originally used by Romans, it means acts done or actus. Okay, this is the doctrine of res geste. And essentials are that the statements made should not be an opinion, it must be a fact. The statement should be made by the participants who are in that transaction, and it should have enough information to explain or to give a brief about the incident, or it is made by the person, or it should be done spontaneously and simultaneously to the main transaction. So there should be no scope of fabrication of evidence in that regard. Now whatever illustrations are given here are very important, please go through that. I'm just going through illustration A is accused of the murder of B by beating him. Whatever was said, so A is accused of the murder of B by beating him. Whatever was said or done by A or B or by bystanders at the beating or so shortly before or after is a form part of the transaction, is a relevant fact, and so it is covered under section 6. Okay. Now come to section 7, facts which are the occasion, cause or effect of fact in issue. Right. So these are the classes of fact you can see: occasion, cause, and effect. Occasion, cause, and effect, immediate or otherwise. This is what is covered under section 7, right? So if you see section 7, it is talking about what, students? Who can tell me? Section 7 is talking about occasion, cause, effect, right? Also it talks about many other thing. If you see, if you go through it in detail, it talks about occasion, cause, and effect. And there is a theory of last seen together theory, which is what section 7 talks about: occasion, cause, and effect, and the theory of last seen together, right? Even opportunity will be covered here, right? Opportunity is also covered here. Now see, last seen together theory, if you see section 106 of evidence act, because I have mentioned when I was talking about this important sections and the slide, I told you that section 106 always come. So it places a burden upon an accused to prove facts, especially within his knowledge, right? So last seen theory together is also coming under this, which is again uh, connected with section 106 also. So it is coming into play where the time gap between the accused and the deceased, okay, the time gap when you saw the accused last alive and the deceased were last seen alive, and if the deceased is found dead, right, the possibility that any person other than the accused was the uh, committed the crime becomes impossible. So there should be no possibility opened of what happened, like last seen together theory together. The time gap is so small that the last time when they were seen together And if the disease is founded, then the possibility is that the person only accused only killed him, right? So there is a strong link between the two to the rule to rule out the possibility of any intervention in between. Okay, so go through this thing. I think if you see the last scene theory that was applied in the case of a very famous case of Arushi murder case, that is Nupur Talwar versus CBI, right? So that is also one thing. Section 7 is facts, occasion, cause or effect, right? Now if you see section 8, it is talking about motive, preparation and previous or subsequent conduct. So how do you behave if there is any motive, if there was any preparation from your side, or whatever conduct you are showing after the previous conduct or some subsequent conduct which can make the accusations more evident, right? Like say for example, A is tried for the murder of B by poison. Okay, so A is tried for the murder of B by poison. The fact that before the death of B, A has procured poison similar to that which was used to B is relevant, right? So your previous conduct is relevant, or your subsequent conduct is also evident. Like say for example, after the commission of crime, you just ran away. You are absconding. That is also showing that this is a subsequent conduct after the commission of crime. So motive, preparation and conduct which is previous or subsequent is also important, which is given under section 8. I hope you all are marking down these in your Bear Act. Now section 9, very important section again, facts necessary to explain or introduce relevant facts. Okay, so any fact which is necessary to explain or to introduce some relevant fact is also important. And section 9 में एक बहुत important चीज कवर होती है, वो है हमारा टेस्ट आइडेंटिफिकेशन परेड. सेक्शन 9 से हमारी एक बहुत इंपॉर्टेंट चीज जो यहाँ पर हमें देखना है वो है टेस्ट आइडेंटिफिकेशन परेड, विच इज given under section 9. So section 9 is better known for this test identification parade, which comes under the subheading of, if you see, facts establishing the identity of anything. अगर आप इस section में देखो, which establishes the identity of anything or person whose identity is relevant. Okay, and that is done by test identification parade, and it is beneficial to both the investigation team also and the accused also, because even the witness is not connected with the accused, so he can identify the offender provided a test identification parade is organized as soon as possible after the commission of crime. Clear to everyone till here? Now come to section 10, things said or done by conspirator in reference to common design, right? So section 10 is my relating to conspirators, okay, who have a common design or who have a common objective, right? So things said or done by conspirator in common design is section 10. Section 11, if you come to, right, come to section 11 now. Now again this section 11 has an importance. Why? When facts not otherwise relevant become relevant, right? When they are not otherwise relevant but they become relevant. And this section has a very important thing related with it, and that is alibi. What do you mean by the term alibi? Section 11 is known for the alibi thing. What do you mean by alibi? Yes, please write in the chat box the meaning of alibi or alibi, however you pronounce it. Anyone who can tell me what is the meaning of alibi? No one? What do you mean by alibi? Taking the plea of alibi. Alibi means elsewhere. Alibi in Latin term means elsewhere. So if an incident has taken place and the accused is charged for that crime, if a crime has taken place and the accused is charged for that crime, then he can take a plea that at the time of incident he was not present there, he was present somewhere else. And if he can show that he was not present at the spot of the commission of crime, but he was present at some other place, then he will be have said to have taken the plea of alibi, right? And if the accused takes the plea of alibi, the burden of proof lies on him only. Under section 103 of this act, you will see the burden of proof lies on him only, right? So section 11 is known for this alibi thing. Yes, he was not present, right, Saurabh? Right, yes, yes, yes. Come to section 12. It's not that much important, right? Section 12, which is in suits for damages, fact tending to enable court to determine amount. 13 is facts relevant when right or custom is in question. Now, if you see section 13, it's talking about facts which are relevant when right or custom is in question, right? So, connected with 13 are other sections also, which talks about customs in this act. So any custom, to validate a custom, you have to fulfill some essentials, that it should be ancient, it should be continuous, it should be peaceful, it should be against not against morality or public opinion, it should be certain, it should be constant, it should be compulsory, it should not be optional, it should be reasonable and not expressly forbidden by law or by any statute, right? So this is regarding section 13, which talks about custom. एंड सेक्शन 13 के साथ आपको पढ़ना है सेक्शन 32 एंड सेक्शन 48, because section 32 and section 48 also are relevant regarding the custom provisions. Okay, so with section 13 you can read section 32 and 48 because they also have provisions relating to custom. Coming to section 14, facts showing existence of state of mind or of body or of body of bodily feeling. Now if you see section 14, right, there are two explanations also attached with this section. So it talks about evidence of similar facts. The state of body and bodily feeling is given in explanation 1, and previous conviction of accused. Right? Previous conviction of accused or people who are repeated offender is given in under explanation 2. Right? You have to go through the illustrations. Like say for example, if I come to the this first illustration only, A is accused of receiving stolen goods knowing them to be stolen. It is proved that he was in possession of a particular stolen article. The fact that at the same time he was possession of many other stolen article is relevant, showing that he knew each and all of the article which he is in possession is said to be stolen only, right? So it is facts which shows the existence of your state or of mind, that you have this, you know the thing. And section 15, if you come to section 15, facts bearing on question whether act was accidental or intentional. Now when there is a question that whether an act was accidental, yeah, if the act is intentional, you have done an act accidentally or you have done an act with a particular intention, the fact that it formed part of a series of similar occurrences in each of the person doing the act was concerned is relevant. So section 15 is an exception to the general rule that evidence of similar fact is not relevant. So evidence of similar fact is not relevant, but section 15 is a exception. So exception becomes necessary to prove a system or a design or to overthrow the defense of accident in cases of habitual offenders or habitual crimes by offender. So this section 15 is laying down all the rules of admissibility of evidences if the question is whether a particular act is incidental or if it is done with a particular intention or knowledge. So this section will raise two questions. This section is raising two questions, whether the act is intentional or accidental. ये पहला question आपको दिखेगा, whether the act is incidental or intentional, right? And the second question is whether it is done with a particular knowledge or intention. Particular knowledge and intention आपको है या नहीं. So first of all, the act should be in, you know, in a series of similar occurrences. The occurrences should be of similar nature. The proximity should be given. The person doing the act must be concerned with each occurrence. Accidental or intentional nature should necessarily be an issue, if you have to keep in mind the application of section 15, right? So go through section 15 also, which is an exception. Now come to section 16. Now section 16 is again important. It talks about existence of it talks about existence of course of business when relevant. Existence of course of business when relevant. So if there is a question regarding the existence of any course of business, whether it is natural to produce a certain result or the mere proof of this existence will give a presumption that the result was produced. Okay. So if it's a course of business, that means a habitual or professional business which is taking place. And if you can, right, then the existence of any course or business, when there's a question whether a particular act was done, existence according to which it naturally would have been done is a relevant fact. So if I'm dispatching a particular letter, if I'm dispatching a particular letter and that letter is not coming back to me, or it is not, you know, in ordinary course of letter, it all the letters were put in a certain place and everything was, you know, dispatched, is a relevant fact. Or it did not come to the dead letter office, that is also relevant fact. That means under the presumption it has been done, under the course of business, that business has been carried out. Come to section 17. Now this section starts with admission, right? So from section 17 till section 30 31, we will see that admission and confession both are defined and the rules are also mentioned here. Now what is admission? If you see the definition of admission, it is given here. It is a statement. Admission is nothing but a statement, right? Oral or documentary or contained in electronic form, which suggests any inference as to any fact in issue or relevant fact, and which is made by any person under the circumstances herein after mentioned. And section 18 is talking about admission by different persons, like by party to proceeding or his agent. Section 19 is admission by person whose position should be proved against party to the suit, right? Section 20 is admission by person expressly referred to by party in suit. Like if the question is whether a horse sold by A to B is sound. The question is whether a horse sold by A to B is sound or not. And A says to B, go and ask C. C knows all about it. In that case, C's statement is an admission. Remember this. Section 21 is proof of admission against person making them and by or on their behalf, right? Section 22, when oral admissions are relevant. 22A, now 22A is also important, when oral admission as to content of electronic records are relevant. 23, if you see, it is admission in civil cases when relevant. So this is the part which is evidence, right? Which is admission, concerned with admission. From 17 till 23, you will see all these forms of admission. Now admission can be judicial, it can be extrajudicial also, right? So whenever you are examining an admission, it should be examined as a whole, right? um, and then if I talk about admission by party to proceeding or his agent, which is given under section 18, right? So this section provides list of people whose admissions are admissible. Section 18 is stating all the parties that admission by a party or to a proceeding or his agent is admissible, right? Then 20 also, when you see, it is by persons expressly referred to by party to suit also is there. Section 21 is proof of admissions against persons making them by or on their behalf. So from section 17 till section 23, you can see it is going with admissions only. Properly, it is only talking about admission. And 22A is again important, right? Now, if I talk about section 21, which lays down the principle as to proof of admission, as you can see, 21, proof of admission against persons making them by or on their behalf. So here, if you see, uh, the section 21 gives three exception to the general rule that admission cannot be used by person who makes it. Right? The general rule is that admission cannot be used by person who makes it, but there are three exceptions also. Admission can be proved by the maker or on his behalf by his representative under three circumstances. If it is of such nature that if the person is dead, it would be relevant as between third persons under section 32. When it is relevant otherwise than as admission, then also it will be it can be proved by the maker. And when it consists of a statement of existence of any state of mind or body made at or about the time when that state, that state of mind or body exists, that is also one of the exception, right? So from 17 till 23, you will only find admission. And in civil cases also, admission is relevant in civil cases also. But there are two exceptions. One is expressly prohibited by parties, and when it is impliedly prohibited by parties, right? So when it is expressly prohibited by parties or impliedly prohibited by parties, then it won't be relevant. Otherwise, in civil cases, it is relevant. And the explanation says of section 23 that legal advisor of the party is not prevented from giving evidence of any communication which is made in furtherance of any illegal purpose or any fact showing that the crime or fraud has been committed. So see the explanation also, which is covered under section 126 also. Now come to confession. Now confession is not defined, but from 24 till 2030, you can see all the sections, important sections relating to confession. Confession is not defined under Indian Evidence Act, right? So let me just finish up with confession and then we can take a minute break. Okay. Let me finish confession and then I'll give you 1 minute ka break. What do you mean by confession? Anyone who knows what is confession? From 24 to 30 you see confession related provisions, but what is confession? Admission का definition तो 17 में है, right? Confession क्या है? What is confession, students? Also please write in the chat box. You can just comment in the chat box, students. What is confession? Confession is a statement which is made by a person who is charged with crime and that suggests an inference as to his fact in issue or as to relevant fact. And that inference suggests that he is guilty of crime. So, if he states that he committed the crime which he is charged with, it is a confession. Or if he is making any statement by which he does not clearly admit his guilt, yet he gives some kind of inference which we can draw that he committed the crime, that is also confession, right? So, admission by accused in the criminal proceeding is a confession if he's admitting that he did the crime, right? A very important case to this is Pakala Narayan Swamy versus Emperor. Okay, Pakala Narayan Swami versus Emperor is an important case. So there is a principle. I'll write down the principle. Wait. The principle is Habemus optimum testim. If you have heard of this principle, Habemus optimum. Anyone who knows the meaning of this principle? Yes, self declaration of offense. See, there is one principle, Habemus optimum testim. If you have heard of this principle, testim confidentiarium. Okay, anyone who knows the meaning of this principle, Habemus optimum testim confidentiarium, it means that best evidence against him used in such cases is a confession against an accused. So confession is nothing but the accused admission of guilt. So confession is a part of admission only. When you are reading from 17 to 31, we have this whole chapter on confession, on admission only from 17 to 31. But 24 to 30 is only dealing with confession. So that comes to a point that all admissions are confession, but all confessions are not admission. All admissions are confession, but all confession are not admission. Okay, so this is a very famous statement that all admissions are all confessions are admission, right? Sorry, all confessions are all confessions are admission. Wait, let me write it again. All admissions are not. All admissions are not confession, right? But all, so all confessions are admission only. Okay, confession is a part of admission only. So all confessions are admissions. All confessions are admissions, but all admissions are not confession. All admissions are not confession. Remember this. Okay, you will find a lot of difference between confession and admission also. Now, confession is of extrajudicial confession also, and retracted confession also, judicial confession also, formal confession, informal confession. Retracted confession comes in your has come once in MP Judiciary ka MCQ. And the meaning of retracted confession is the action of drawing back something. So first you voluntarily make a confession, but afterwards you retract or you revoke it. Then it is a retracted confession, right? Come to section 24. Confession caused by inducement, threat, or promise is when irrelevant in criminal proceeding. So if you are confessing, come to 20. Now all these sections are very important, starting from 23 till 30, 31. Now this chapter is as a whole important. So any confession caused by inducement, threat, promise, when irrelevant in criminal proceeding, tell me. When is it irrelevant? If you see the ingredients of section 24, it says that the statement, if the statement in question is a confession, and such confession has been made by accused, and it has been made to a person in authority. So the accused has made a confession to a person in authority, and that confession has been obtained by reason of any inducement, like the person who is in authority, he has given some kind of inducement, threat, or promise, right? And this inducement or threat or promise has reference to the charge against the accused. Then this inducement, threat, or promise must, in the opinion of court, be sufficient to give the accused a ground which is making him, like, for supposing that if he's gaining any advantage or if he's avoiding any evil of temporal nature in reference to the proceeding against him, in that case those kind of statements, right, is irrelevant. If it is appearing to the court that it is caused by inducement, threat, promise, right, from a person in authority. So whenever you are giving a confession, it should be voluntarily. It should be a voluntary confession. It should not have been caused by inducement, threat, or promise. Now, who is a person in authority? Who stands in a relationship that he has a control or that he can interfere regarding the statement of the accused, right? So this is 24. Now come to 25 and 26, very interesting section. Confession to police officer is not to be proved. So if I give any confession, any statement regarding to the crime to a police officer, that is not admissible, because previously there used to be a lot of torture and a lot of violence by the police to extract a false confession. So law is not giving any confidence, into in a police officer. So if a person is confessing in front of someone else, it will not be irrelevant just because of the presence of policeman around, but still it's saying that, um, if you are confessing to a police officer, until otherwise, it is not admissible, right? And a police officer is one who has the power to investigate also, or who has the power to submit a police report, or any police officer who is dealing with your case, right? You cannot give a that confession to him is not relevant or not admissible. Confession by accused while in custody of police not to be proved against him. Now this is talking about the custody, and there is an explanation also where magistrate does not include head of village discharging magisterial functions and all. Again, section 26 is here to prevent abuse of power by police. So any confession made by accused person even in custody of police cannot be proved against him unless it is made in presence of a magistrate. So if he is making in a custody in front of magistrate, that is allowed, that will be acceptable, but otherwise in a police custody it is not admissible, right? Now section 26 does not apply to judicial custody, because police officer do not have independent control over the accused in judicial custody, but in police custody they do have. Come to section 27, how much of information received from accused may be proved. Very important section. How much information is received from accused can be proved. Very important section. Now if the following, like if the specific knowledge of the accused or the place from where something can be discovered, or the object whatever is discovered has been taken from the accused, if there is a discovery of fact, right, in consequences of the information which the accused has given, that can be proved. But there is a proviso or exception. That means section 27 starts with the word, when it starts with the word provided, if you can see, provided that. So since it is starting with the term provided that, and it is after this section 26, hence 27 is automatically a proviso to section 26. So section 27 is an exception to, or is a proviso to section 26. So section 26 is generally not allowing the admissibility of confessional statements in police custody, but section 27 allows the discovery part of the statement. So section 27 is an exception to 26, right? Remember this, section 27 is an exception to 26. This is an important part. It comes in MCQs also. Section 27 is an exception to 26. So though you cannot um, confess in a if you are confessing in custody of police, it is not to be proved against him, but if some discovery has been made relating to the statement given by the accused, then that will be admissible, that much can be proved. So section 27 automatically becomes an exception to section 26 and also to 25. And if you come to section 28, any confession made after removal of impression of this inducement, threat, or promise is relevant. So section 28 is again an exception to section 24. Section 28 is again an exception to section 24. Come to section 29, confession otherwise relevant, not to become irrelevant because of promise of secrecy. So if in criminal cases, what happened, if an accused person is promised that आप बोल दो ना, I we will not say to anyone, आप बता दो हमें, आप कन्फेस कर लो, हम किसी को नहीं बताएंगे, वी आर, आप बताओ कि कौन अक्यूज्ड है या किसने क्राइम करा है, we will not say to anyone, and the person confesses it by assuring him that your statements will be kept a secret, or that the evidence will not be given against him, then the confession is relevant. Even if you are obtaining it by fraud or intoxicating the accused, it is relevant. But one exception is there to section 29, right? That first आपको accused को when we are saying that you have to give a warning to the accused regarding that. So section 29 is clearly declaring that confession will be relevant even though the accused was not given the warning, that he is not bound to make the confession. However, if you see section 164 of CRPC, it expressly requires the magistrate shall give the warning to the accused, right? That it might go against him. Section 30, confession of co-accused, which is made by under, now this is very important to understand because यहाँ पे joint trial की बात हम कर रहे हैं. सेक्शन 30 में हम बात कर रहे हैं जॉइंट ट्रायल की. So if two or more persons are being tried jointly for the same offense, then the confession made by one person will also affect the other person. But अगर joint trial नहीं है, then it will not affect. So see, this illustration comes in MCQ also for 30. A and B are jointly tried for murder of C. A and B are jointly tried for murder of C. It is proved that A said B and I murdered C. Then whatever A statement has given, it will go against B also because it's a joint trial. But if it's a separate trial, if it is not jointly tried, A is on trial for the murder of C, right? And if and B said A and I murdered C, this statement will not be taken against A because B is not being jointly tried. Remember that. So this section 30 will only work for joint trial, not for separate trial. Please start giving your if you want to ask any question, if you want to give any feedback, please start giving it. 31 is admissions not conclusive proof but may stop, right? So again, this admissions, they are not conclusive proof but can act as a stopple. Come now, before I start 32, we will take 1 minute ka break and then I'll start 32. Okay, so let us come to section 32. Statements by persons who cannot be called as witnesses, right? So can a dead man be called a witness? What do you think? Can we call a dead man a witness? Please write your answers. Now section 32 has a very important section which is under clause 1, and that is when it relates to the death of a person, right? So it's dying declaration. So these are the cases in which statement of relevant fact by person who is dead or who cannot be found is also relevant. So these are the people who are dead or who cannot be found, but their statements are relevant when it relates to the cause of his own death, like dying declaration, or if it is made in the course of business, or against interest of maker, or if it gives opinion as to public right or custom. I told you, when I was doing section 13, I told you to refer to section 32 and 48 also. So 32 ka clause 4, right? Read it with section 13. Or when it relates to existence of relationship, or if it is made in will or deed, or in document, or is made by several persons and expresses feeling relevant to matter in question. So there are 8 clauses, but the first clause, which is relating to dying declaration, is really important, right? So when the statement is made by a person who is no more, who is dead, and he has talked about his own cause of death or circumstances of the transaction, right? It can be oral, it can be by gesture, it can be by sign, it can be in form of question and answers which he has expressed in, right? So the object or the doctrine behind, the principle behind this dying declaration is that nemo moriturus presunum presunusimtur mentu. That means a man will not meet his maker with a lie in his mouth, right? So what is the principle behind this uh, dying declaration section? It's nemo moriturus presumitur mentir, है ना? Nemo moriturus presumitur mentire, mentire. That means a man is not going to meet his maker with a lie in his mouth. So I'll just write the principle here. Right, so this is the principle nemo moriturus presumitur mentire, and this is the section relating to dying declaration, correct? So I'm not going to the details because we have a limited time to complete the whole thing, right? So if you have any doubt, you can ask me regarding that also. Come to section 33 now. Relevancy of certain evidence for proving in subsequent proceeding the truth of facts therein stated. Just go through it. I'm not going through it. Then 34, statements made under special circumstances, like entries in books of account when relevant, right? When are the entries in book of account relevant? So if you see section 34, I hope you all are seeing this. If you see the illustration, A sues B for rupees 1000 and shows entries in his book showing B to be indebted to him to this amount. The entries are relevant but are not sufficient without other evidence to prove a debt. So what happens here is that when you read section 34, 238, which is talking about the statements which is made under special circumstances. um, Relevancy of certain evidence which is for proving, right, in subsequent proceeding. You have to show that the entries in the book of accounts regularly kept in the course of business, or the entries in public documents or in document of public character. So both classes of statement are admissible or relevant. So this is based on the principle that if you are making an entry regularly in the course of business, it will be accurate. It is surely to be accurate if it is regularly maintained, right? So this is about the book of account regularly kept. Section 35, relevancy of entry in public records. 36 is relevancy of statement in maps, chart and plans. 37 is statement as to fact of public nature. Okay, so we can skip this section and uh, come directly to 40. 40 is important. Previous judgment relevant to bar a second suit or trial, right? So previous, if you see this section 40, how much of a statement is judgment of courts or justice when relevant, and it says previous judgment is relevant to bar a second suit or trial. Which um, which doctrine do you get is reflected here? Which doctrine is reflected in section 40 of Indian Evidence Act? Please someone tell me. Which section 40 can if you read section 40, do you think it is reflecting to something? Have you read such provision somewhere else in any other statute? So section 40 to 44 is talking about judgment of court of justice when relevant, but do you feel section 40 is reflecting some other thing also? We have read section 40 somewhere else also. No answer. Is section 40 reflecting some other doctrine which we have read in any other statute? Previous judgment is relevant to bar a second suit or trial. Very good, Arunima. Right, Arunima. Res judicata. Very good. So, yes, very good, Arunima. So, the legal maxim behind res judicata, which is res judicata pro veritate acceptor, that means if I am accepting a decree by a court as finally resolved, right? So, the same principle we see in section 40 also, right? And the same we also get in section 300 of CRPC and article 20 clause 2 of Indian constitution. So from 40 to 44 you have this only. Come to 45, which is opinion of third person when relevant. Now this is talking about opinion of third persons, and 45 talks about opinion of expert, right? Opinion of expert is given under section 45, and it mainly, if a court has to form an opinion, okay, if the court wants some opinion on foreign law, because court cannot be experts in everything, so they call experts who are who know about, who have the knowledge about foreign law, or of science, or of art, or as to identity of handwriting or finger impression. In that case the court can take the opinion of expert. Now the opinion here is like whatever knowledge they have, and they are giving their opinion on that. An expert is a person who is expert, or he's a skilled person in that particular field. So section 45 is talking about foreign law. Expert opinion is required in foreign law, science and art, identity of handwriting, identity of finger impression, and electronic evidence, right? But also you see that section 46 talks about the evidentiary value. Evidence 45A is important. It can come for your MCQ also, right? Opinion of examiner of electronic evidence. When in a proceeding, the court has to form an opinion on any matter relating to information transmitted or stored in any computer resource, or this, the opinion of the examiner of electronic evidence is relevant fact. And what are the facts bearing upon opinion of expert? Now, this is something which is giving the evidentiary value of expert opinion, and it says that facts not otherwise relevant are relevant if they support or if they are inconsistent with the opinion of expert when such opinions are relevant, right? So just go through 47 and 48. Now 48, again, as I told you, it's related with section 13 and 32 also. Okay, so from here till section 46, 47, 48, 49, and till 55 you will see, not 55, till 50, 51 you will see it goes to the opinion as to third person. Okay, then 52 and 53 talks about character when relevant. So how is character relevant in evidence, and whether it is relevant or not, if a good character is relevant, if a bad character is relevant, given under 52, 53, and 54. So from 52 to 55 you will see it's relating to character when relevant. Now character is again a very important evidence because it is a combination of quality. So you can understand the character of a person from his past action, right? You can understand his character from his past action. 52 says that evidence of a party's character cannot be given for the purpose of showing that it is rendering his conduct imputed, okay, as probable or improbable. So if you see 52 and if you see 55, right, there are two sections, 52 and 55, and here you will see that 55 is an exception to section 52, right? 55 is an uh, exception to 52. So in civil cases the general rule is that evidence of character of any person concerned in a suit is not admissible for the purpose of raising an inference as to his conduct. So character becomes character, if it is admissible or not admissible in civil cases. There are cases in which character is a fact in issue or a relevant fact, right? Like if libel is concerned or something like that is concerned, then it would be a fact in issue, and then the evidence of the character can be led. But in civil cases, evidences of character is generally inadmissible unless character is only the fact in issue, right? And section 55 talks about character as affecting damages. So in civil cases, the fact that the character of any person is such to affect the amount of damages which he sought to receive, then it will be relevant. So, and then there is an explanation also attached. And if I talk about criminal proceedings, in criminal cases, previous good character is relevant. Bad character is not relevant, but good character they consider under section 53, right? So this is regarding that. Come to part 2 on proof. Now part 2, facts which need not be proved. So facts which are judicially noticeable need not be proved. This is again very important chapter. Please go through all the things here because it talks about facts which need not be proved. So if a fact can be taken judicial notice of, it need not be proved if I can take a judicial notice of these facts. And which facts are judicially noticeable? Some facts are there which you don't need to prove. Like if I want to talk about the laws in force in the territory of India, the court will take judicial notice of that fact under section 57. These are the fact of which court should take judicial notice, and I don't need to prove it by any way. So there are 13 clauses here, like all laws in force in the territory of India, all public acts, right, passed by Parliament of UK, and all local and personal acts, articles of war of Indian Army or Navy or Air Force, the course of proceeding of Parliament of UK, accession and sign manual of sovereign, all seals of which English court take judicial notice, the seal of the courts in India, and etc etc. So all these, like also the existence, title, and national flag of every state, right? The territories under the dominion of government of India, all this thing you don't need to prove. If you The court will take judicial notice of this fact, right? So the facts which are admitted, again 58 says the facts admitted need not be proved. Now come to chapter 4 of oral evidence. chapter 4 Chapter 4 of oral evidence. Proof of facts by oral evidence. So you can prove all facts, right? All facts may be proved by oral evidence. All facts may be proved by oral evidence, except the exception is content of document or electronic record. And whenever you are proving by oral evidence, it should be direct evidence. So oral evidence should be direct. You can give oral evidence, but that should be direct, right? That means it should be seen by the person who is claiming to have seen it. It should be heard by the person who says he heard it. It should be perceived by the person who claims that he has perceived it, or if it is referring to any opinion, it must be the evidence of that person only who is holding that opinion. And there is a proviso also relating to it, right? If I come to documentary evidence, the contents of document can be proved by primary or secondary evidence, right? So oral evidence is given under section 59, and it should be direct. Section 60 says it should be direct. 61 says proof of content of document which can be given by primary or secondary evidence. Primary evidence is 61, and secondary 62, and secondary evidence is 63. Remember these sections because sections come. Okay, primary evidence is defined where, secondary evidence is defined where. Now secondary evidence is these things: certified copies, xerox copies, है ना? These are the secondary evidence. Photograph, all these are secondary evidence. Primary evidence is the original document. It's the original document, and these are the explanations given to primary evidence. How will you prove document by primary evidence? Documents must be proved by primary evidence only. So first you have to give the original copy only to everything. Section 64 says. But in some cases you can also give secondary evidence under section 55 if the original is not in the position or power of the person who is wanting to prove it, है ना? Or these are the reasons. Or if the original, the existence condition or the content is proved, okay, to be admitted in writing by the person against whom it is proved, or when the original is destroyed or lost, or when the original is of nature which cannot be moved, or when the original is a public document within the meaning of section 74, right? Now what is section 74? Section 74 talks about public document. We will come to that also. And then you have 65A, special provision as to evidence relating to electronic record, and 65B also, where how will you admissible the electronic records which are admissible, right? So these are all the sections where you can find this part where we can prove our documentary evidences. Okay, now one thing which is again important is proof as to electronic signature and proof of execution of document required by law to be attested. So if a document is required by law that it has to be attested, then it cannot be used as evidence until you also bring the attesting witnesses. At least one attesting witnesses has to be called who can prove it. And if attesting witnesses are not found under section 69, if you cannot find the attesting witnesses, in that case it must be proved that the attestation of one attesting witness, you at least have to prove the handwriting of the witness and the signature of the person who executed the document, right? So this is regarding attestation of witnesses who have executed the document, the ones who have executed and the ones who have witnessed that execution. Okay, come to public document. What is public document under 74? These are public document. Documents which are the acts or records of sovereign authority, of official bodies, of public officers. Public records also which are kept in private document form are public records, and private documents are all other documents are private, right? So 74 is public document, 75 is private document. So just go through these sections also which is relating to that. Now I'm directly going to 91 of exclusion of oral by documentary evidence under section 91. If you have any doubt in between, please ask me. If there is any doubt in between, please ask me. Right? Now see, this is evidence of terms of contract grants and other disposition of property reduced to form the document. So if the terms of a contract or of a grant or of any other disposition as already reduced in the form of document, and it is required to be in document, then you cannot give you know oral evidences of such fact. You have to give documentary evidences only of such fact, right? So you have to give the document itself, right? If required, you can also give the secondary evidence of those document, but oral evidence cannot be required. Like uh, if you see the exception, when a public officer is required by law to be appointed in writing, and when it is shown that now these are the two exception or wills which are admitted in probate, may be proved by probate, and these are the explanations to it. Now coming to most important part, which is of burden of proof. Now burden of proof is a very important chapter in part 3, production and effect of evidence. We are coming to, and under production and effect of evidence, if I show you one important part which is there, is this chapter of burden of proof, right? So burden of proof is a very very important chapter. You cannot miss the sections here. Section 101 is talking about burden of proof, which is never shifting. Okay, just see the burden of proof here. Section 101 talks about burden of proof and onus of proof. These are two different terms. The burden of proof is the obligation that you have to prove a fact, right? So section 101 talks about burden of proof. And burden of proof is of two kind. One is burden of proof on pleading, one is burden of adducing evidences. Now here 101 is burden of proof, and 102 is the burden of proof which is shifting, but under 101 the burden of proof is not shifting. Under 102 the burden of proof shifts. 101 is permanent burden of proof, 102 is the shifting burden of proof, and 103 is a particular, it is referring to a particular kind of burden of proof as to a particular fact. Section 104 is the burden of proving fact to be proved to make evidence admissible. Like if you see A wishes to prove a dying declaration by B, then A only has to prove the death of B. 105 talks about burden of proving the case of like the accused is coming within some exception which is given under IPC. If the accused wants to take this plea that he is coming under the general exceptions of IPC or within any special exception or proviso, then the burden of proof will be on him only, right? The burden of proof will be on him. Section 106 is very important. It talks about burden of proving facts, especially within the knowledge, right? This comes a lot in MP also. So when a person does an act with some intention, and he has a special knowledge of that fact, then he only needs to prove it. So if you are charged with traveling on a railway without ticket, the burden of proving that you have a ticket is on you only. Now 107 is presumption of continuance of life. So if it is if some person is alive within 30 years, if the question is that whether a man is dead or alive, and it is shown that he was alive within 30 years, then the court will presume that he is alive. So this is presumption of life. And if you are asserting no, he's dead, then you need to prove that he is dead. 108 talks about presumption of death. So if a man is not heard for 7 years by those persons who should have naturally heard of him, then he is considered to be dead unless someone else proves that he's alive. And if you are asserting that he's alive, then you have to prove it. Okay, burden of proof as to relationship in cases of partner, landlord, tenant, principal, and agent. 10110 talks about burden of proof as to ownership. And 111, if you see, it's a proof of good faith in transaction where one party is in relation of active confidence. So if you know I can prove that one party is in active confidence, and there is a burden of proof that whether the transaction is in good faith or not, then the burden of proving the good faith is on the person who is on the superior position or on the position of active confidence. So for example, if a son is selling some property to his father, then the burden of good faith is on the father, because it might happen that the father induced the boy by undue influence. So if that is the case, the father has to prove the good faith. 11A says about presumption as to other offenses. 112 is very important. It is the conclusive proof of legitimacy. It is an irrefutable presumption of law. Remember, 112 is irrefutable presumption of law. So if any child is born during marriage, during the continuance of a valid marriage, or within 280 days after the dissolution of marriage, and the mother has not married any other person, it's a conclusive proof that the child is a legitimate son of the man to whom she was married. Okay. Now there is an exception. If the man can prove that he had no access to her at the time when she conceived, then it will be a different case. Otherwise, it will be a conclusive proof of legitimacy. This is 113's proof of cessation of territory. 113's presumption as to abatement of suicide by a married woman. Again, an important section. So when the question is whether the commission of suicide by a woman had been abated by her husband or any relative, and it can be shown that she was within the period of 7 years, husband and her relatives were subjecting her to cruelty, then the court will again presume, it will may presume that she died because of she was abated to suicide. Okay. So cruelty, if you see, you will can see 498 of IPC. Presumption of as to dowry debt, again 113B, if the woman is subjected by by her husband or by by his relatives to cruelty or for harassment in relation with dowry, again the court is going to presume that the person caused her dowry death. Dowry death is defined under section 304B, and this is court can presume existence of certain other facts which you can see here, right? And 114A again is presumption as to absence of consent in certain prosecution for rape. So this is regarding the chapter of BOP. Now coming to estoppel, 115 defines estoppel, right? So if you are declaring something and due to your declaration some other person is acting on that declaration and acting something, then later you cannot be allowed to deny the truth of which you have made the statement. And estoppel is of many kind. Okay, there are many kinds of estoppel. There is estoppel by deed, there is estoppel by pious, there is estoppel by record, estoppel by conduct also. Now estoppel by pious is estoppel by conduct only, right? There is estoppel by if you go through go through this estoppel thing, you will see different kinds of estoppel. And it is estoppel by conduct, it is estoppel by negligence and other kinds. But in 115 you will see it is talking about estoppel by pious. Okay, this 115 talks about estoppel by pious. Now come to 118, very important, of witnesses chapter. Who may testify? Who can testify? Students, can you tell me, can a minor or can a unsound mind person testify under Indian Evidence Act? What do you think? Can a minor or can a person who is unsound mind, a lunatic, is he competent to testify? Yes or no? Can a person who is unsound mind testify or not? Tell me. Who are competent to testify, students? Is a person of unsound mind competent to testify under Indian Evidence Act? See, it's written all persons are competent to testify. All persons are competent to testify unless the court considers that they are not able to understand the questions, or they cannot give rational answers, or because of their tender age, or because of their um, old age, disease, something of body or mind, they are prevented from understanding the questions or giving rational answers. Otherwise all persons are competent to testify. So a lunatic is also competent if he can understand the question and if he can give rational answers. Then 119 is talking about witnesses who are unable to communicate verbally. So it talks about dumb witnesses. 119 talks about dumb witnesses, okay? So if a person cannot speak, he can give his evidence in writing or by signs, right? Then parties to civil suit and their wives and husband or wife of a person under criminal trial. So can a husband give evidence against his wife, or for his wife, or can the wife give evidence, right? So these are the sections where you have to go through the child witness part. Police also as a witness, then can be chance witnesses, there can be stock witnesses, there can be material witnesses also. 118 is talking about that all persons are competent to testify if they can understand the question and if they can answer it rationally. 119 talks about dumb witnesses. 120 is talking about parties to civil suit and their wives or husband. 121 is regarding judges and magistrate, right? Then come to this privileged communication, which is under this chapter only. Now, there are some communications which should not be disclosed. They are privileged communication, like between spouses, between husband and wife. The communication, whatever is during marriage, it's a privileged communication, right? Or evidence as to affairs of state. So, privileged communication you can see from 126 to 129. Again, very important. Official communications also, no public officer can be compelled to disclose communication which has been made to him in official confidence. Professional communication 126, again very important, where barrister, attorneys, pleader, vakil, they are unless with his clients express consent, they cannot be permitted to disclose any communication, right? And but there is this exception if it's a communication made in furtherance of any illegal purpose or any fact which is observed by the barrister, pleader, or attorney. So these are the privileged communication portions, and the illustrations are very important. Like if a client says be to his attorney, I committed forgery and I wish you to defend me, so this communication is protected from disclosure. But if a client says to be, I wish to obtain possession of property by use of forged deed, and I request you to sue, then this is in furtherance of a criminal purpose. So it is not protected. It is not a privileged communication. And 126 will apply to the interpreters, clerks, and servants also, right? So this talks about privileged communication. Now coming to 133, which is accomplice. Who is an accomplice? Accomplice is also a competent witness against an accused person. A accomplice is also a competent witness. And if a conviction is held on the basis of accomplice's statement, it is not illegal just because it is upon the uncorroborated testimony of an accomplice. Okay, so whenever you are reading 133, read it with 114. So 114 and 133 needs to be read together. How many witnesses are required to prove a particular fact? There is no particular number of witness. It can be one, it can be two, it can be 100. But remember one thing, witness number is not something which matters. It is the quality of the thing which you are giving. So witnesses number do not matter here in under Evidence Act, right? If there is one witness also who is giving a honest a thing, an honest statement, that is enough to convict someone. So the number of witnesses is not required. Acha, whenever you are reading 133 accomplice section, you have to read it with 114 as I told you. Right? Now, of examination of witnesses, if you see, Again, this chapter 10 is one of examination of witnesses, but here 137 is important. 137 talks about the examinations. Okay, what is examination in chief, what is cross examination, what is re examination? Who can tell me what is examination in chief and cross examination and re examination? See, if you are calling up, if you are the person, you are calling your own witness, and the you are examining your own witness, that is examination in chief. So it is by the party who calls him. Cross examination is the examination of witness by opposite party, and re examination, examination of witness after cross examination by the party who called him, that is re examination. So what should be conducted first? A witness shall be first examined in chief. देन इफ एडवर्स पार्टी सेज कि मेरे को भी एग्जामिन करना है, तो वो क्रॉस एग्जामिनेशन कर सकता है, एंड देन अगर वापस से पार्टी को करना है तो वो री एग्जामिन कर सकता है, राइट. एंड 141 talks about leading questions. Okay, it talks about leading questions. Now leading questions are those questions which under 141, if you see, which suggest the answer, right, which the person who is putting it is wishing to receive. So anything like you want to receive this answer only, so you are suggesting a question which will you are putting up a question which will suggest that answer only, so that is leading question. Okay, when will leading question not asked, students? Leading question should not, if objected by adverse party, be asked in examination in chief or in re-examination except with the permission of the court, right. And when will they asked? When they can be, leading question can be asked in cross examination, right. These are all provisions relating to cross examination and uh, examination in chief. So cross examination as to previous statements in writing is again important. What questions you can ask during cross examination? Okay, so you can ask questions which is testing the veracity to discover who is this and what is his position in life. Or if you want to shake his credit, you can ask questions which will shake his credit also. Then coming to 151, which is indecent and scandalous question. So you cannot ask questions which are indecent and scandalous, and if the court feels that the questions are indecent and scandalous, then it will forbid you to ask it, right. So the court will forbid any question which is indecent or scandalous, right. 152, if you are asking question intending to insult or annoy someone, court will forbid you to do that, right. Come to 154. Now 154 relates to hostile witnesses. So sometimes it may turn out that the party who is calling the witness has turned hostile against that party only. So if I called A and A is now giving such statements which is against me, then he is considered to be a hostile witness, right. And 154 talks about hostile witnesses. So the court will, in its discretion, permit the person who calls a witness to put question to him, which might be put in cross examination during this time, right? 155 is impeaching the credit. Coming to 159, which is refreshing memory. So it might happen that the witness has forgotten something. So to refresh his memory while under his examination, right, he can be allowed to refresh his memory, referring to any writing which he made at the time of transaction or whatever, right. So that is refreshing memory, and he can use copy of document also to refresh his memory. 160 relates to testimony to facts stated in document mentioned in 159. 162 is production of documents. So a witness is can be summoned to produce a document, and if he's summoned to produce a document, and if it is in the position and power of witness, he will bring it to the court, right, notwithstanding any objection which there may be to the production or admissibility, right. So he can produce it, and the court, if it sees fit, it can also inspect the document. And we have 165, where the judges also have power to put questions or order production of something. So the judges will have that power that they can put question, or they can order production of something, right, that is dealt with under 165. 166 deals with power of jury or assessors to put question. So in cases which is tried by jury or assessor, they also have the power to put question to the witness. It can be through or by the leave of the judge, and the judge can also put that if he considers it proper. Okay. Now, does the judge has the power to ask question? That you can see in 165. So in order to discover anything, if he wants to discover or obtain any proper proof of any relevant fact, he can also ask question, right? The provisos are there. And 167, which is the last, under the last chapter of improper admission and rejection of evidence, no new trial for improper admission or rejection of of evidence. So if an evidence has been improperly admitted or rejected, right, that is not a ground for a new trial. This is what 167 says. So section 167 is saying that improper admission or rejection is not a ground for initiating a new trial or for reversing a decision if there is enough evidence to justify the decision, or if the evidence that has been rejected had been received, right? So if the evidence which is rejected or not or admitted improperly is not so significant that it would have anyway uh, change the decision, or if change the decision of the court. So if it is the case, if an appeal is filed on the ground of improper admission or exclusion, then it is okay, but you cannot start a new trial. And this section is applicable to both criminal and civil cases, right? And the object here is that the court of appeal or revision should not disturb a decision on the ground of improper admission or rejection, right? So this is regarding section 167. And then we have the schedule, which was already repealed, right? So I hope Evidence Act, we have just done a rapid revision of whatever, and in the starting only I mentioned all the important sections. Please go through them. If you have any question, you can ask me now. So students, the floor is open for you to ask any question or anything if you have, right? Otherwise, please go through the important sections which I have mentioned at the starting of the class. And thank you for being patient and letting me complete this act. All the best for your exams. I hope you all do well, right? So we can end the session now. Thank you, everyone. Yes, section related to cross examination. Yes. So if you see, it starts from 137, right? This starts from 137. Examination in chief, cross examination, re examination, and then cross examination sections are given after this. 137, yes. Section 137 is defining all the examination in chief, cross examination, and re examination also, right? Yash, are you asking this only? So it is 137, and after that you have other the following sections after 137 relates to all this examination and what can be done during that. So they are all extended sections of these examination only, right? Any other question? So we can end the session now. Thank you so much, and all the best, students.